May I introduce my fellow panelists? On my far left is Professor Sami Selçuk, who I'm sure will be well known to everybody here from Turkey. He was, as you know, the first president of Turkey's Court of Cassation. He was a former leading prosecutor and is a much published and widely respected criminal law academic. On my immediate left is Helena Lisuchova. She is from the Czech Republic, and she is the head of her country's International Cooperation Department at her Ministry of Justice. And she's also the head of the Czech delegation to GRECO, which is the European Council body dealing with anti-corruption. And on my right is Bill Sorrell, who's the Attorney General for the state of Vermont in the United States. He has been since 1997 and has been consistently re-elected ever since. He's been a state lawyer as well as a lawyer in private practice for a good little while. A lawyer and a member of parliament who talks too much. That's me. He's been a lawyer and a state-employed lawyer as well as a private practice lawyer for a good little while, but he's also done a great deal of voluntary and charitable work as well in his home state. So, what I'm going to try and do is to facilitate and to stimulate the discussion about threats to the rule of law, although I hope, given the distinguished panelists either side of me, I'm not going to have to work too hard. I'm anxious not to delay proceedings unduly, but before we get to their contributions, I have been asked to set out a few initial thoughts of my own on the rule of law and the threats which it faces in many countries today, and it has been widely said, in contemporary Turkey. In particular, I want to draw on my own experiences in supporting and in developing and in implementing the rule of law during my career, both as a member of the bar in London, where my practice for the last nearly 40 years has focused predominantly on the interaction and conflict between freedom of expression and the right to privacy and reputation. My career as a British Member of Parliament since 1992 and as a government minister. Nowadays, we describe that conflict through the prism of the European Convention of Human Rights, and in particular, Articles 8 and 10, but it is a conflict that has been dealt with for centuries under the common law of England and through statute. And despite our 60-year or so membership of the Convention and our ability since the implementation of the Human Rights Act of 1998 to have convention points decided in English courts, these are not new issues, and they are still very much affected by the common law. As a Member of Parliament, I have legislated twice in the last 20 years to adjust the law of defamation in my country, and I have participated in parliamentary debates about the relationship between the executive, Parliament, and the media, most recently in the context of a judicial inquiry headed by Lord Justice Leveson into phone tapping and other criminal activities by the tabloid press. And as Her Majesty's Solicitor General, one of the two government law officers, I had, amongst many other things, to protect the rule of law and the administration of justice by policing our laws of contempt of court, by making sure that the media and individuals did not publish information that could prejudice court proceedings, particularly criminal trials. These experiences highlight three critical areas of significance in the context of contemporary Turkey. First, the independence and role of the legal profession and the judiciary. Second, the role of the executive in implementing and sustaining the rule of law. And third, the role and significance of a free, independent, and thriving press. As the four professors told us this morning, there is no single orthodox definition of the rule of law, but for the purposes of this introduction, I propose to adopt as a working definition that of the late Lord Bingham, one of my country's most eminent recent jurists, where in his pithy book entitled The Rule of Law, he wrote that the core of the principle is that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future and publicly administered in the courts. The problem, of course, with any definition of the rule of law is that it is just that, a definition. And we can only really understand the potential range and implications of any threats to the rule of law if we also understand that the rule of law is not just a formulaic definition devoid of content. It doesn't mean simply rule by law, where the content of those rules is irrelevant. Although an essential and integral part of the law, the rule of law is a clear, defined, and prospective legal framework, the mere codification and de jure existence of a set of principles doesn't suffice to protect and implement the rule of law. Take, for example, Nazi Germany. Although elements of the constitution were suspended after 1933, Hitler and his National Socialist government were elected and governed ostensibly under the Weimar Constitution until their defeat in 1945. There are constitutional arrangements in all sorts of countries that on their face imply the existence of the rule of law, but which experience tells us does not exist sufficiently or even at all. Zimbabwe has a constitution and a recognizable judicial system. Russia and the Soviet Union before it has a constitution and a justice system, but I'm not sure I would want to have any commercial or criminal dispute arbitrated in those jurisdictions, especially if the government or a friend of the president of either country had a more than passing interest in the matter. In contrast, the United Kingdom does not have a codified constitution. Our attachment to the rule of law is sustained by a series of historical conventions that have the force of law. Are these Professor Gherkin's soft law? Statutes approved by Parliament, hard law, the cumulative decisions of judges, and international treaties. While our system is far from perfect, no one would sensibly suggest that the rule of law operated more effectively in Germany under the Weimar Constitution in 1938 or in Zimbabwe than it did or does in the United Kingdom then or now. Now, one of the greatest threats to the rule of law is a literal and formulaic approach to its implementation. It'll be lost on no one in this room that many of the greatest threats and inroads to the rule of law in the last 100 years have been said to have taken place not only because they were in accordance with the law, but because they were necessary to protect the rule of law. Whether it was Ralph Waldo Emerson or Dr. Samuel Johnson who first came up with this line doesn't matter for present purposes, but it is apt when thinking about governments that claim to be taking away constitutional freedoms in order to protect them to remember it. The more he talked of his honor, the faster I counted the spoons. Now, the lesson of history is clear. When the executive itself invokes the need to protect the rule of law in the name of the public or national interest, all elements of society, the judiciary, the legislature, the media, and the people on whose behalf the executive acts, need to be at their most vigilant to ensure that the fundamental principles which underpin the rule of law are not eroded or misused. The public interest and the maintenance of the rule of law are frequently used to justify incursions into the principle of the rule of law on the basis that they are necessary for the safety of the public and the preservation of the state. In the late 20th and early 21st centuries, the threat posed by international terrorism has particular significance in this context. Clearly, if the state succumbs to its external enemies, the rule of law will be lost. Yet equally, if the state does not uphold the basic principles of law and justice when faced with such threats, its citizens may well be in no better place than if it had succumbed to that external threat. Only a few years ago, in the final months of the Labour government that lost office in the general election in my country in 2010, it tried to introduce 90-day detention without charge. And I stress without charge, not pre-trial in suspected terrorism cases. My party, the Conservative Party, was against it. The Liberal Democrats, our current coalition partners, were against it. And sufficient numbers of the Labour Party were against it to ensure that the government dropped its plans. Under our system, the government is accountable to Parliament. And here was an example of the government with, on paper, a commanding majority in the House of Commons having to bow to the will of Parliament. I often say in our system that the executive sits in Parliament. Here was an example of it trying to sit on Parliament, and it failed. Of course, the threat of terrorism in the United Kingdom was and remains high, but very few MPs wanted to protect liberty by eroding it. The words of the great 17th century English philosopher John Locke remain as valid today as they were in the 17th century. Wherever law ends, tyranny begins. I've already said that an independent and fearless judiciary and an independent and fearless legal profession are fundamental to the maintenance of the rule of law. No better example of this can be found in a case argued in 1941 at a stage in the Second World War when our fortunes were not at their best, about a government minister's powers to detain those whom he had reasonable cause to suspect to be of hostile association. That case was called Liversidge and Anderson, and it's worth reading all 5 of the judgments handed down in the House of Lords, then our highest appeal court. But if you only read one, read the dissenting judgment of Lord Atkin, and his words bear close scrutiny, and I will, if I may, quote them. "I view with apprehension," he said, "the attitudes of judges who, on a mere question of construction, when face to face with claims involving the liberty of the subject, show themselves to be more executive-minded than the executive. In this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which, on recent authority, we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law." I merely note that as recently as last month, Prime Minister Erdogan was widely reported as making critical comments about the Constitutional Court's decisions concerning Twitter, about the High Council of Judges and Prosecutors, and the law on internet. And he's reported as stating that this constitutional institution is defending the commercial law rights of international companies, while it should be defending the rights of the public. Everyone should know their place and their boundaries. Everyone should know their authority. Well, no doubt we should all know our place and where the boundaries are. I'm just not sure that a politician is the right person to tell the citizen or a judge what his place should be or what the boundaries that separate the powers within the constitutional settlement should be. In understanding the importance of the rule of law, politicians and judges alike would be wise to read all of Lord Atkin's speech in Liversidge, and in particular his concluding remarks when he refuted the majority's strained interpretation of the statute in order to give the Home Secretary, our Interior Minister, broader powers to detain persons in a time of war. He said, "I know of only one authority which might justify the suggested method of construction. When I use a word," Humpty Dumpty said in rather scornful tone, "it means just what I choose it to mean, neither more nor less. The question is," said Alice, whether you can make words mean so many different things." I'm not sure how many of you are familiar with the works of Lewis Carroll or Alice in Wonderland, but Lord Atkin made sure that his fellow law lords were made a little more familiar with them. Lawyers are, of course, highly skilled and well practiced at making words mean so many different things, but the fundamental principles which underpin the rule of law are immutable. It is perhaps understandable that politicians who are responsible for maintaining the national security and who are accountable to their electorate may see a short-term solution to knotty and difficult questions. The role of the independent judiciary is to see the broader consequences of any erosion of the rule of law and to act as a check on the power of the executive. And it was Lord Bingham, who I quoted earlier, who remarked, "There are countries in the world where all judicial decisions find favour with the powers that be, but they are probably not places where any of us would wish to live." Judicial independence is therefore an essential constituent of the rule of law. If the guardians of the rule of law do not or cannot strive to preserve the rule of law, there can be little hope for the ordinary citizen. Now, threats to the rule of law come in many forms. Corruption in the public or the private sector is one of its more invidious forms, undermining both the principle of equality before the law and the consensual social acceptance of the rule of law. Traditionally, the United Kingdom has had low levels of corruption, and we've been loath to do much more to bring the laws against bribery and corruption more up to date, not least because it was not easy to find an acceptable definition of a corrupt gift or payment. It was always easier to recognize than to describe, so we left the law as it had been for about 100 years. The Bribery Act 2010, however, is now widely regarded as one of the toughest in the developed world, not least because of its Section 7, which criminalizes the failure to have systems in place to prevent corruption. This shows the importance of evolving and developing measures to protect the rule of law, not remaining static and complacent. Complacency is, of course, itself a major threat to the rule of law, but I complacently like to think that the Bribery Act demonstrates a lack of complacency on the part of British legislators. On a related issue, another major threat to the rule of law in far too many jurisdictions, and indeed worryingly in my own country, is the accessibility of justice. All too frequently, access to justice in the rule of law is the preserve of the rich and the powerful. Access to justice, both in the criminal and in the civil courts, must be available to all, otherwise equality before the law exists on paper and not in practice. But only last week in London, a major fraud trial was halted because the defendants were not able to secure adequate representation due to cuts in public funding for criminal defendants. The inability to secure adequate representation and to achieve equality of arms with the prosecution undermines not just confidence in the justice system, but the rule of law itself. And although I am a member of the government party, my opposition to the changes to public access to the law are well known. They will lead to injustice for the individual victims of crime and for society as a whole, and to some extent, of course, to the defendant, because society expects the guilty and the innocent alike to be fairly tried before the criminal courts. It's highly dangerous and something on which all those involved in the legal profession have a particular duty to guard against. And I should add that the judge who stopped the prosecution did not do so out of political bias against the government, but in support of the rule of law. And as a further aside, which may amuse those of you who have followed the turbulent saga of the unproven corruption allegations disclosed by social media here in Turkey of late, the lawyer representing the defendants in this fraud case in London, who in the best traditions of the bar appeared for his impecunious clients for free, was none other than the British Prime Minister's older brother. In England, we have two law officers, the Attorney General and the Solicitor General. They are government ministers appointed by the Prime Minister for the party of government, from the party of government, and they are usually members of Parliament with all of the constituency obligations of any other MP, although they can also be members of the upper house. And they accept collective responsibility for government policy and decisions just like any other minister. But they are different to other ministers in that they ought to be lawyers of some standing in the profession, and the Prime Minister cannot tell them what to do in their role as law officers. They superintend, but they do not manage the state prosecution agencies, the Crown Prosecution Service and the Serious Fraud Office. They cannot direct that someone be prosecuted, and when a politician is to be prosecuted, they're not even consulted about it. Over the last few years, a number of members of Parliament and members of the House of Lords have been prosecuted for making dishonest expenses claims. And a few weeks ago, the Deputy Speaker of the House of Commons was prosecuted, although I add, was acquitted, of sexual assault and rape charges. The law officers were not told what the evidence was, whether they might or might not be prosecuted, nor were they consulted about the political fallout of those prosecutions. And had either law officer attempted to interfere or to influence the process, they would have lost their jobs at once. The British law officers are also the chief legal advisors to the head of state, the Prime Minister, and the Cabinet, and in that role, they give dispassionate and confidential legal advice and represent the government in the higher courts, in the European Court, and in the European Court of Human Rights in Strasbourg. They do not temper their advice to suit their political party or to appease an irate Prime Minister. They speak truth unto power. And if the Prime Minister doesn't like their advice and wants it changed so that the unlawful can appear lawful, they say no. And if he still insists, they resign. And when a law officer resigns because his advice to government is politically unpalatable, you then have a constitutional crisis, and then more likely than not will lead to the resignation of the Prime Minister. This nuclear option is politically the only weapon the otherwise politically weak law officers have, and it has not been used for many years because the unspoken respect for the rule of law and the separation of powers is more powerful than the desire to get away with breaking the law. I have frequently described the law officers as submarines. They are at their most effective when they are unseen and they are unheard. If they surface, it usually means they're in trouble or the government's in trouble. They don't reveal the advice on the law they have given the government any more than a lawyer in private practice would broadcast the advice given a client. They patrol the inner reaches of government, making sure that it and its political ministers, who are most effective when they are seen and heard, comply with and uphold the rule of law. There are no statutes setting out what the law officers can or cannot do, save for one very small and short law which allows each to do the work of the other if he is absent. Their behavior is governed by their own professional standards and practice, built up and adapted since the 14th century. Their loyalty is first to the rule of law, second to Parliament, and only thirdly to the administration of which they are a member. Lastly, and I appreciate I'm going on, lastly, I want to touch on an area which I know has been much discussed in Turkey, namely the role of the media and freedom of expression in preserving the maintenance of the rule of law. Not quite 15 years ago, the said Lord Bingham, who I've quoted earlier, said this in an appeal concerning a former member of the security services who was being prosecuted under the Official Secrets Act 1989 for handing secret information to the press. This is what Lord Bingham said. The reasons why the right to free expression is regarded as fundamental are familiar, but merit brief restatement in the present context. Modern democratic government means government of the people, by the people, for the people. But there can be no government by the people if they are ignorant of the issues to be resolved, the arguments for and against different solutions, and the facts underlying those arguments. The business of government, he said, is not an activity about which only those professionally engaged are entitled to receive information and express opinions. It is or should be a participatory process, but there can be no assurance that government is carried out for the people unless the facts are made known, the issues publicly ventilated. Sometimes, inevitably, those involved in the conduct of government, as in any other walk of life, are guilty of error, incompetence, misbehavior, dereliction of duty, even dishonesty and malpractice. Those concerned may very strongly wish that the facts relating to such matters are not made public. Publicity may reflect discredit on them or their predecessors. It may embarrass the authorities. It may impede the process of administration. Experience, however, shows in this country and elsewhere that publicity is a powerful disinfectant. Where abuses are exposed, they can be remedied. Even where abuses are already being remedied, the public may be entitled to know that they occurred. The role of the press in exposing abuses and miscarriages of justice has been a potent and honourable one, but the press cannot expose that of which it is denied knowledge. Now, the argument at that appeal was whether the Act complied with the defendant's rights to free expression under Article 10 of the European Convention, and whether he had a public interest offence. And it was held that the Act was a prima facie restriction on his right to freedom of expression. The restriction was nonetheless prescribed by law and directed to the objectives specified by Article 10 of the Convention. The question was whether the restriction was proportionate or not, as the ban under the Act was not absolute, but provided for disclosure with lawful authority, provided the correct procedures were followed, sufficient and effective safeguards to satisfy Article 10 of the Convention had been provided. Sadly for Mr. Shaler, his appeal was dismissed. On one level, it's understandable why some politicians and people in authority don't want to be subject to scrutiny, but we can't, in a democracy under the rule of law, have one rule for some and another for the rest of us. If it's right that there is no public interest in the dissemination of false information, it is also right that there should be greater public access to genuine public information. Last year, England abolished the offence of scandalising the court. It was contempt of court, knowingly to publish derogatory statements about the judiciary or individual judges, where those statements would undermine the administration of justice generally or public confidence in it. The original justification for the offence was famously described by one judge as the need to keep ablaze a glory around the judiciary and to deter people from attempting to render them contemptible in the eyes of the public. Now, this was a statement from the 18th century, which shows how far both the rule of law itself has evolved in the United Kingdom, but moreover, how the consensual basis of the rule of law has evolved. Although interestingly, there was a case in the Privy Council last week dealing with this form of contempt of court from Mauritius, where the Privy Council upheld the existence of that form of contempt of court in the context of the Mauritian constitution. Keeping the judiciary in an ivory tower, however, poses as great a threat to the rule of law as impugning the judiciary's integrity with false and malicious criticism. Any restriction on freedom of expression, even on false and unjustified criticism, has or could have a chilling effect which deters justified criticism. Although this was an offence which had fallen into disuse some time ago, the abolition of this archaic restriction has reinforced the rule of law and the principle of accountability of all before the law. The internet undoubtedly poses unique opportunities and challenges alike for freedom of expression. It is no respecter of boundaries and legal jurisdictions. The Arab Spring was kept going by social media. The United States and British governments have faced with the Snowden and the WikiLeaks revelations all sorts of difficulties and embarrassments. The internet can be both a force for good and for bad. It can reach way beyond the realms of ink and paper. It has put the English jury system, one of the bulwarks of our criminal justice system, under huge strain because it can no longer be safely assumed that jurors will only have access to the information they have heard in court. An English court order prohibiting the publication of information prejudicial to the defendant is not enforceable against a blogger in California. The internet is no respecter of government. The ban on Twitter in Turkey was easily circumvented. An injunction with no effect is no injunction. King Canute knew he could not control the tides. The courts and the politicians cannot independently control the tide of the internet. So we must willingly and pragmatically adapt our laws and our practices to cope. So that was my overlong introduction, and I would now very much like to invite Bill Sorrell to say a few words. Then I was going to ask Helena, and then I'm going to ask the professor. So Bill.
Thank you, Sir Edward. And let me join those who thank the organizers for inviting me to participate in this extraordinary symposium in this extraordinary city. Also want to say that looking at the list of the presenters for the two-day symposium, I'm humbled by the caliber of my fellow presenters. I am not a legal theorist. I am not an academic. I work as the chief law enforcement officer of my state in the trenches, if you will, in making decisions to try to further the rule of law and to enhance justice. I'm an elected statewide office holder, so I answer only to the voters of my state. They decide whether I remain in office. And my jurisdiction or authority is not limited just to the criminal law. I and my assistant attorneys general who work for me have the authority to prosecute all state criminal laws, from shoplifting up to and including murder. But also we enforce, prosecute violations of our environmental protection laws, our consumer protection laws, our antitrust laws against anti-competitive behaviors in commerce, our campaign finance laws that set the rules during for spending and gathering of money during collecting money in conjunction with campaigns for elective office. And we enforce our civil rights laws against discrimination in the realm of employment. So have broad jurisdiction and authority. It's a demanding job, but at the same time, it's a job that provides very rewarding opportunities to enhance the safety, health, and quality of life of Vermonters and other Americans. I thought for my remarks, I would start with what is really the guidepost for me as I approach my job, and that is the oath of office that I take at the beginning of each of my terms of office. So this is an oath that I've taken in a very public forum 8 different times. And it's not long, it's actually quite brief and has 3 main provisions. First is that I swear that I will be true and faithful to the state of Vermont, and that I will therein that I will not directly or indirectly do any act or thing that is injurious to the Constitution of the state or the government of the state. So that provision, I essentially swear allegiance to the bedrock of our system, our state constitution, and to the government. And then there's a second, very brief provision where I swear that I will support the Constitution of the United States, the bedrock of the whole system in the United States of America. But it's the third provision that I really want to focus on today as we talk about threats to the rule of law. And in that third provision, I swear that I will faithfully execute the office of Attorney General for the state of Vermont, and that I will therein do equal right and justice to all persons to the best of my judgment and ability according to law. And I submit to you that if you pay attention to that oath of office, and particularly that third provision that I just talked about, that's a tall order. Because if you look at the wording to do equal right and justice to all persons, that means that in deciding to commence investigations, to conduct investigations, to choose to bring charges or alleged violations of state statutes, whether civil or criminal, that I'll show no favoritism to my friends or my family, nor to those in my political party, nor to those of my race or religious persuasion. The flip side of that is that I won't single out for persecution or special treatment those individuals who are enemies of mine, or not enemies, but maybe those whom due to race, ethnicity, where they live, political persuasion, religious beliefs that are different from mine. Those individuals who perhaps I just feel less comfortable with than others. It was suggested this morning that no system, the rule of law, is perfect. It's certainly not perfect in my state nor in my country. And that's just looking at the system. But the justice system is run by individuals. And just in the same way that no system is perfect, individuals are not perfect. And so we're subject in making our investigative and enforcement decisions to trying to be aware of our own individual biases, our fears, our discomforts, and try very hard to set those aside and to not have them have an influence on the decisions that we make. At the same time, I don't think there's any question but that a justice system under the rule of law does not mean that everyone is treated exactly the same no matter what the situation. Nor are those of us who make our subjective decisions to investigate or to enforce, to prosecute, to convict, nor are we robots, but rather we're asked to make our best subjective decisions. That same oath of office that I've mentioned, I administer, and I make a point personally of administering to each and every one of my new assistant attorneys general. And I ask them to consider the language of the oath and what that means. I also bring another consideration, raise another consideration, particularly for those who are going to be working for me in the enforcement arenas that I've just mentioned, or in working with what we could call vulnerable populations. Those, for example, who are in the custody of the state because of they haven't been convicted of crime, so they're in prison. Others who perhaps due to mental health needs or issues have been taken into custody by the state so that they may receive care, either in an institutionalized setting or out in the community under some strict supervision. Similarly, there are the children whom we take into custody because they have been abused or neglected, or the cases that we bring in the most severe of abuse and neglect cases where we seek to terminate the parental bonds of parents so that children may be placed for adoption, particularly for those assistant AGs who are going to be working in those kinds of enforcement arenas or involved in cases involving those citizens who are vulnerable and in state custody and control. I tell them to go read the ethical rules that govern lawyers in the state of Vermont, but with particular emphasis on those provisions that talk about government lawyers, enforcement lawyers. And we, under those rules, are not simply to play by the rules of court, nor are we simply to be zealous advocates for whatever position we're espousing. Rather, we have some special provisions under the ethical rules, and that is not to just be a zealous advocate, but to seek justice, so that prosecutors under our system, our jobs are quasi-judicial, if you will. And I tell my people that you are to seek justice as you go about performing your duties. And I was in New York City at a meeting last week, and on one very rainy night, I was walking along the street and saw all these people with umbrellas, or hopefully umbrellas, lined up along the sidewalk. And I thought, what could keep everybody here with this torrential downpour? And then I looked up on a marquee or whatever, and it's the opening of the new Spider-Man movie. So I was reminded of another thing that I tell my assistant AGs, and these sentiments were at least attributed to Spider-Man. I suppose that's true, but I know my mother said them to me a very long time ago, and that is, with great power comes great responsibility. And so I tell those who work for me following the suggestion this morning of the panel this morning, to exercise restraint. You have such great power under our system. Give yourself room for error by exercising restraint. Underuse your power rather than overuse your power. Now, I've said that I very much like my job. Now I wanted to talk just for a minute or two or three about something that I don't like, and that when I have experienced it in Vermont, and I'm aware of it elsewhere, I think is just plain wrong. And that is undue meddling or interference with me and my office trying to do our jobs in terms of deciding what cases to investigate, how those investigations are conducted, making the prosecutorial decision to bring charges, and then to resolve cases if possible. I think the independence of the judiciary is hugely important, but the independence of the prosecutors and investigators is hugely important. And when I have had situations when prominent people have tried, in my view, to show favoritism to some or much less favoritism to others, I have considered for me to have done that, or to even really consider doing that, to be a violation of my oath of office, and certainly inconsistent with the rule of law. Professor Pildes this morning talked about a situation in U.S. history of President Roosevelt so-called packing or trying to pack the Supreme Court. I want to talk a little bit about the slightly more contemporary U.S. history and the situation involving the highest levels of meddling or intermeddling with the justice system, and a situation that many consider to be have been a very sad chapter in U.S. legal history. And if you do an online search and look up the term Saturday Night Massacre, you'll see elaboration of what I'm going to talk about right now. But the Saturday Night Massacre, very briefly, is flowed from the so-called Watergate affair in 1972 during a presidential election campaign. But first, let me just sort of set some context that the 60s and the early 70s were times of tremendous turmoil in the United States. In 1963, our young progressive president, John Kennedy, was assassinated before his time. In spring of 1968, Martin Luther King, a civil rights leader in the country, was assassinated. And just a month or two later, the late President Kennedy's younger brother, Robert, a candidate for president, another progressive candidate, was assassinated during his election campaign. During the 60s, the United States, in early 70s, the United States was involved in a very unpopular war in Vietnam. And there was great turmoil in the country on civil rights, in the civil rights arena. In June of 1972, a handful of men with former ties to the U.S. intelligence services were arrested breaking into the headquarters of then President Nixon's opposition party, the Democratic Party, and they were looking to plant a bug in the offices. And as investigation continued, serious questions arose as to whether the highest levels of the U.S. government were behind the so-called Watergate burglary. Ultimately, concerns that there be a fair and independent examination of these connections, there was calls for a special prosecutor. And an esteemed Harvard Law professor, former Solicitor General of the United States, Archibald Cox, was named a special prosecutor to investigate and decide who had violated our laws, no matter how high, and to respond accordingly. And in the fall of 1973, in October, Archibald Cox, having learned that there were some recordings allegedly made in the Oval Office of the White House that might have subject matter that was relevant to his investigation, and he issued a subpoena for the so-called White House tapes. President Nixon and those answerable to him declined to respond to the subpoena. And they offered a compromise. October 19th of 73, the special investigator, Archibald Cox, special prosecutor, rejected the compromise and said the subpoena stands. And on the next day, President Nixon called his Attorney General, Elliot Richardson, whom he appointed, and told him to fire Archibald Cox. Elliot Richardson declined, resigned from office. The job of Attorney General went to the number 2, also an appointed position, William Ruckelshaus. He was told to fire Archibald Cox. He refused and resigned from office. Finally, the third in line, an individual named Robert Bork, did in fact fire Archibald Cox. That set off a furor in the country. It set off a furor in the president's own party. That there would be this kind of intervention in this investigation and the actions of the special investigator who was just doing his job. Fast forward to the next year, to 1974, the president was reelected in November of 72. The 73, the Saturday Night Massacre. 74, the president, facing certain impeachment and conviction before the Congress, resigned in disgrace. Several of his top-level staff were imprisoned, and thus the end of the so-called Watergate affair, or basically the end. Low point in U.S. legal history, indeed, but ultimately, arguably, a high point in that ultimately justice prevailed. So I point that out to show that we've had our issues in the United States, as you do here in Turkey. But dedication to the rule of law can not only earn, but maintain and increase respect for the rule of law and those who administer justice. Thank you for letting me participate.
Thank you very much indeed. Thank you. I'm now going to ask Helena Lisuchova to address us.
Thank you very much. First of all, I would like to thank also the organizers for organizing this event and for inviting me on behalf of GRECO to inform you on our activities and processes and the current monitoring that is going on. Which is very pertinent to the theme of the rule of law, threats to rule of law, and to the situation of Turkey at the moment. So GRECO, or the Group of States Against Corruption, was established in 1999 as a enlarged partial agreement by 17 member states of the Council of Europe. Enlarged partial agreement means that not only members of the Council of Europe are invited to participate, but also other countries. At the moment, members are all 47 member states of the Council of Europe, plus 2. We have the USA and the Belarus, which joined as the latest member. GRECO's objective is to improve the capacity of its members to fight corruption by monitoring, and that is done through mutual evaluation and peer pressure, to monitor the compliance with Council of Europe anti-corruption instruments, which set standards in this area. Namely, those are the 20 guiding principles for the fight against corruption and the criminal and civil law conventions on corruption, and an additional protocol to the criminal law convention. GRECO's monitoring comprises of an evaluation procedure which is based on on-site visits and followed up by an impact assessment, so-called compliance procedure, designed to appraise the measures taken by its members to implement the recommendations emanating from country evaluations. In its previous rounds, currently we are in the 4th evaluation round, in the previous rounds GRECO dealt with a wide range of issues, such as anti-corruption bodies, immunities of public officials as possible obstacles in the fight against corruption, the protection of individuals, the whistleblowers. Those are the individuals who report suspicions of corruption, the confiscation of corruption proceeds, incriminations provided for by the Criminal Law Convention on Corruption, and the transparency of party and election campaign fundings. The current 4th evaluation round, which was launched in January 2012, is devoted to corruption prevention in respect of members of parliament, judges and prosecutors. The outcome of the 4th evaluation of Turkey would be most interesting with regard to the theme today discussed, but Turkey has not been yet evaluated, nor my country for that matter, the Czech Republic. So I can only use examples of from 14 countries that have already undergone the evaluation, and their reports have been published. 3 more reports were adopted in our December plenary meeting, but we are still waiting for the authorization of publication. The theme of the 4th round has clear links with GRECO's previous work, notably the 2nd evaluation round, which examined the executive branch of public administration. Focusing on corruption prevention in respect of parliamentarians is a continuation of GRECO's scrutiny of political financing during the 3rd evaluation round and prevention of corruption regarding judges, including lay judges, and prosecutors represents an in-depth follow-up to a particularly important element of the 1st evaluation round, and that was the independence of the judiciary. As I have mentioned in the beginning, GRECO monitors standards set by legal instruments of the Council of Europe. The most important in respect of Statute of Judiciary are the Criminal Law Convention, resolution from 1997 on 20 guiding principles for the fight against corruption, and recommendation of the Committee of Ministers on Judges, Independence, Efficiency and Responsibility, which has been adopted in 2010. The Convention's principal aim is to harmonize the criminal laws of contracting states in respect of corruption offenses. The parties undertake to adopt such legislative and other measures as may be necessary to establish as criminal offenses the different forms of corrupt behavior enumerated in the Convention. This obligation applies to bribery, both active and passive, of domestic and foreign public officials, including judges and prosecutors, national and foreign parliamentarians, as well as members of international parliamentary assemblies, officials of international organizations, judges and officials of international courts, and to bribery in the private sector. It also applies to trading in influence, account offenses, and the laundering of proceeds from corruption offenses. The 20 guiding principles adopted by a resolution in November 1997 were elaborated by the multidisciplinary group on corruption, which was in fact the predecessor of Group of States Against Corruption. 2 principles, namely Principle 3 and 7, are focusing amongst others on independence of judiciary. Principle number 3 reads that those in charge of the prevention, investigation, prosecution and adjudication of corruption offenses enjoy the independence and autonomy appropriate to their functions, are free from improper influence and have effective means for gathering evidence, protecting the persons who help the authorities in combating corruption and preserving the confidentiality of investigations. Principle number 7 obliges the states to promote specialization of persons or bodies in charge of fighting corruption and to provide them with appropriate means and training to perform their tasks. The performance of Turkey in these areas has been evaluated in 2005. GRECO was provided with all the relevant laws and articles of the Constitution, with the information on the appointment of the Supreme Council of Judges and Public Prosecutors, members and applicable at that time, and with the procedure of appointment and securing the independence of judges and prosecutors. Already at that time, in 2005, GRECO recommended to further enhance the independence of judges vis-à-vis the Ministry of Justice concerning their supervision and appointment. In 2007, when the compliance report has been adopted, assessing the progress of Turkish authorities with implementation of the recommendation, GRECO observed that there was no real progress in ensuring greater independence of judges on the executive powers in relation to their appointment and supervision, which were still tightly linked to the Ministry of Justice. The final assessment has been made in 2008 when Turkish authorities reported on the preparation of the judicial reform strategy plan, which we've heard today went through with several different stages of reforms. Although there was some progress, as was assessed by GRECO in 2008, the major obstacle remained, and that is that the Ministry of Justice has still been represented by the minister himself, and that he remained the chair of the plenary of the Supreme Council. But as the reform of judiciary has still been going on at that time, the recommendation has been assessed as partly implemented. GRECO has not been dealing with the issue further because that evaluation round has been terminated in respect of Turkey in 2008. All these and more issues are dealt with in more depth during the current monitoring round launched in January 2012. These are based on the third important standard-setting document that I mentioned earlier, and that is the recommendation on judges from 2010. Turkey will be monitored in coming years as to its abidance with these rules. I will cite some of the recommendations, just that you are aware of the scope of the assessment. Paragraph 4, in fact, states that the independence of individual judges is safeguarded by the independence of the judiciary as a whole. As such, it is a fundamental aspect of the rule of law. Other parts of the recommendation state that the independence of the judge and of the judiciary should be enshrined in the Constitution or at the highest possible legal level. Where judges consider that their independence is threatened, they should be able to have recourse to a counsel for the judiciary or another independent body. Another important message is contained in Chapter 2 in the external independence of judges, which is not a prerogative or privilege granted in judges' own interest, but in the interest of the rule of law and of persons seeking and expecting impartial justice. The independence of judges should be regarded as a guarantee of freedom, respect for human rights, and impartial application of the law. With regard to internal independence, the recommendation states that judges should be independent and impartial in their decision-making and able to act without any restriction, improper influence, pressure, threat or interference, direct or indirect, from any authority, including authorities internal to the judiciary. The standard-setting document also covers the establishment of councils for the judiciary as independent bodies, which seek to safeguard the independence of the judiciary and states that not less than half the members of such councils should be judges chosen by their peers from all levels of the judiciary. In exercising their functions, councils for the judiciary should not interfere with the independence of individual judges. Status and career, tenure and irremovability of a judge and his liability, as well as ethical codes for judges, are also covered by the recommendation. All these questions are of interest to GRECO during the fourth evaluation round. As I have said before, Turkey has not been evaluated and won't be evaluated in 2014. So I will speak generally about the areas that emerged from those 14 publicly accessible reports. The main focus is on, First, transparency, accountability, rule of law, and independence. Judicial and prosecutorial careers, codes of conduct for judges and prosecutors, and members of parliament. All three areas, all three groups of people are covered. Conflicts of interest and the issue of gifts. Declarations of assets, income, and liabilities, including the question whether spouses and other close relatives of the person have to report on their assets and income, and disciplinary measures. The question of existence of Judicial Council, its composition and powers always triggers huge debates in the plenary. Such self-governing bodies of judiciary responsible for recruitment, careers, but also financial matters are the ones considered to ensure independence of judiciary. When a Judicial Council, when a Judicial Council in a country is established, its composition is subject to analysis. There was not one country yet that has not established such council. I have to say that in my country, in the Czech Republic, we do not have a Judicial Council, nor the Council for the Prosecutors. So I expect when we are evaluated, probably in 2015, we will receive some very hard and pointed recommendations. GRECO always assesses whether the composition of such councils complies with the recommendation of ministers, meaning whether membership of judges is at least half of all members and the way members are appointed to the council. For example, the former Yugoslav Republic of Macedonia received a recommendation which says, in order to strengthen the independence of the judiciary from undue political influence, ex officio membership of the Minister of Justice in the Judicial Council should be abolished, although the minister could not be a president of the council, nor could he vote on the appointment or promotion of the judges. Powers of such independent bodies are evaluated as well, especially with regard to appointment and career progression of the judiciary. In case of Latvia, GRECO recommended to strengthen the decisive influence of the relevant self-governing judicial bodies. In Latvian case, that is the Judicial Council and the Judicial Qualification Board, and decrease the risk of political influence of the Latvian Parliament in the appointment, reappointment, and career progression of judges. I should explain here that the Latvian Parliament, the Saima, confirms judicial appointments, which are done by the Judicial Qualification Board. This in itself may not be problematic, but must be properly safeguarded. Another point of interest is the question of incompatibilities of functions of judges and prosecutors. Interestingly, under the laws of the Netherlands, judges, except for judges of the Supreme Court, may be members of either of the chamber of the Parliament. For the duration of their mandate, they are on leave from their judicial office. GRECO considered this as a possible threat to independence and impartial execution of the judge after his or her return to court, and therefore recommended to restrict the simultaneous holding of office in the Parliament and of a judge by law. Those, I believe, are the main findings so far in the so far adopted reports with regard to the theme of today's meeting, the rule of law and connected independence and impartiality of judiciary. If you are interested, all the reports are published at the website of GRECO, or I can give you some further information later. Thank you very much.
Thank you very much. Some of you may have been looking at the timetable. I have used my moderator's immoderate discretion since we started a little later, not to reduce the time that we have to hear Professor Selçuk. So please do not feel inhibited by looking at the thing which says finish at 3:30. You will not. Unless you want
Teşekkür ederim Sayın Başkan. Bu güzel şöleni düzenleyen arkadaşlara da teşekkür ediyorum. Hem de kutluyorum. Meslektaşlarımla beni buluşturdukları için de kutluyorum. Benden önceki konuşmalar çeşitli ilkelere değindiler ve bu arada iki ayrı sistem ortaya çıktı. Dikkat ederseniz birisi Anglo-Sakson sistemi, öbürüsü Kara Avrupa sistemi. Hemen oradan bir noktaya dikkatinizi çekmek istiyorum. Anglo-Sakson sistemi ile Kara Avrupası sistemini birbirinden kesinlikle ayırmak gerekir. Deminden beri hukuk devletinden söz ediyoruz. Arada bir de hukukun üstünlüğünden söz ediyoruz. Hukukun üstünlüğü Anglo-Sakson merkezlidir. Kara Avrupa sisteminde ise hukuk devleti ilkesi ortaya çıkmıştır. Ben birincisini yeğliyorum. Bu ikisini birbirinin yerine kullanmıyorum. Önce onu özellikle belirtmek isterim. Tabii hukukun üstünlüğü bir idealdir, bir ülküdür. Sürekli ardından koşulması gereken bir ülküdür. Biraz önce çok güzel bir tanım getirdi Sayın Başkan, hukuk devleti ile ilgili olarak. Fakat ben daima hukuk devleti kavramının ya da ilkesinin içerisinde üstü örtülü bir biçimde devletin hukuk içinde olmadığının ve sürekli onu hukuk içine çekme kavgasının bulunduğunu düşünürüm. Nitekim Kara Avrupa'sındaki bu savaş hiçbir zaman bitmemiştir. Bugün de Türkiye'de aynı kavgayı biz veriyoruz. Ama hukukun üstünlüğü dediğiniz zaman devletle birey aynı düzeydedir. Neyin karşısında? Hukukun karşısında. Çünkü hukuku yapma tekeli Anglo-Sakson sisteminde devletin tekelinde değildir. Kara Avrupa'sında devletin tekelindedir. Önce onu özellikle vurgulamak istiyorum. Şimdi buradan bu hukukun üstünlüğü ilkesinin gerçekleştirilmesi elbette hem Anglo-Sakson sisteminde sabahleyin de belirtildiği üzere hem de Kara Avrupa sisteminde kolay olmamıştır. Türkiye biraz gecikerek bunun kavgasını vermektedir. Bugün de veriyor ve bazen de dikkat ederseniz bu kavga doruk noktalarına kadar yükseliyor, çatışmaya kadar gidiyor. Şimdi Fransa'ya baktığımız zaman hemen oradan bir örnek vermek isterim. Eğer Victor Hugo'nun evini ziyaret etmişseniz ve ona bir Paris'e yolunuz düştüğü zaman ziyaret etmenizi tavsiye ederim. Evin girişinde Cosette'in bir heykeli var. Cosette bir kovayı taşımaktadır. Ama içeriye girdiğiniz zaman içeride kurşun kalemlerle yapılmış birkaç resim görürsünüz. Bunlardan bir tanesi de ressam Viet'in bir kurşun kalemle yaptığı resimdir. Tarihe dikkat ettim, 1911. Yine bir kova taşınmaktadır. Uzaktan baktığınız zaman Cosette kovayı taşımaktadır. Ama yakına geldiğiniz zaman kovayı Jean Valjean taşımaktadır. Ve güçlü kolları ile. Ressam bu resmin altına şunu yazmıştır. Cumhuriyetin cılız kolları. Çünkü Cosette'in kolları henüz o kovayı kaldırmaya yetmemektedir. Şimdi dikkat ederseniz 1911 tarihi pek de geç bir tarih değil. 1790 ile 89 ile 1911 arasını düşünürseniz demek ki hala bu kavga verilmektedir. Şimdi onun için bütün bu tarihi gelişime baktığım zaman Türkiye'deki gelişmeyi biraz hoşgörüyle karşılıyorum. Ama Türkiye'nin önünde çok güzel örnekler varken neden bir çırpıda bunu çözmüyor? O zaman kahrolmaya başlıyorum. Bu mesleğe 40 yıl emek vermiş bir insan olarak şunu söyleyeyim. Bugünkü konu Konunun başlığı hukuk devletine yönelik tehditler. Biraz önceki konuşmacılar ülkelerindeki yolsuzluklar üzerine ağırlığı verdiler. Doğru. Eğer bir ülkede yargı bağımsız değilse, özellikle kamu görevlilerinin yolsuzluğunu kovuşturmada güçlükler ortaya çıkabilir. Kamuoyuna da tatmin edici bir resim çizemezsiniz. Bu kesin. O nedenle yine iş dönüp dolaşıp nereye geliyor? Yargı bağımsızlığına geliyor. Şimdi bir ülkede eğer yolsuzluk varsa ceza hukuku, hatta bütün hukuk değerleri korur. Yolsuzluklar konusuna gelince rüşvet, eğer bir devlette, bir düzende rüşvet sık sık işlenen bir suç ise rüşvetin çiğnediği değer devletin tarafsızlığıdır. Tarafsızlık yoktur. Bazılarını devlet satın alınabilir bir aygıttır. Bazılarına ne yapıyor? Kayırmada bulunuyor, işlerini daha kolay yapmalarını sağlıyor. Eğer bir devlette zimmet suçu var ise, sokaktaki yurttaş ödediği verginin devlet işleri için değil, kişilerin çıkarları için kullanıldığını düşünüyor. Eğer bir ülkede yasalara uymadan bazı şeyler yapılabiliyorsa, bu görevde yetkiyi kötüye kullanmadır. Biliyorum çoğunuz diyeceksiniz ki görevi kötüye kullanma. Hayır, görev kullanılmaz. Ya yapılır ya yapılmaz. Doğru terim yetkinin kötüye kullanılmasıdır. Yani kamu görevlisine verilen yetkiyi yasal sınırlar içerisinde kullanmadığınız takdirde ne yapmış olursun? Bu suçu işlemiş olur. Yani devlet demek ki yasaların dışına çıkarak iş gören bir aygıt haline geliyor. Bütün bunların üstesinden gelmenin yolu ise özellikle sayın meslektaşımın da belirttiği gibi yargının bağımsız olmasıyla mümkündür. Bunun başka bir çaresi yoktur. Kamuoyunun güçlü olduğu ülkelerde tabii ki yargının bağımsızlığı büyük güvence altındadır. Ama cılız olduğu ülkelerde bu güvence ne yazık ki yeteri kadar değildir. Yargı bağımsızlığı dendiği zaman ben tek boyutlu ele almıyorum. Birincisi, yargıçların ve bir ölçüde savcıların yasama karşısında bağımsız olmalarıdır. Nitekim Türkiye Cumhuriyeti Anayasası'na bakarsanız, zaten anayasanın 138. maddesini okursanız, dış dünyadan kendinizi soyutlayarak okursanız dersiniz ki ne güzel bir düzen bu. Sorun onu gerçekleştirmekte. Dört dörtlük bir yargı bağımsızlığı tanımını orada bulursunuz. Ama sorun uygulamaya yansıtmakta. Şimdi yasamaya karşı bağımsızlık, az çok Türkiye'de bu oluyor. İşte yasama organının önüne gelen konularda herhangi bir görüşme yapılmıyor. Ama bunun yanı sıra siyasetçiler her gün söylüyor, konuşuyor. Tam değil. Onu baştan söyleyeyim. 2. Yürütmeye karşı bağımsızlık. Asıl kıyamet burada kopuyor. Nedir yürütmeye karşı bağımsızlık? 2010 tarihinde yapılmış olan reform bana göre doğru değildi. Yani doğru olan kesimi vardı, doğru olmaz. Ben size açıkça söylüyorum. Şu anda 40 yıllık meslek yaşamımdan çok iyi biliyorum ki Türkiye'de yargıç olarak bağımsız insanlar sadece yüksek yargı organlarında görev yapanlardır. O kadar. Hayır, taşradakiler değildir. Onu bilesiniz. Bu bir. 2. Yürütme organının bir üyesi olan Adalet Bakanı eğer kendisine bağlı bir kurulun, kendisine şu anda tamamen bağlanmıştır, başkanı ise tam bağımsız olsa bile o kurul, başkanlık ettiği, oy kullandığı sürece o kurulun Bağımsız olduğunu söyleyemezsiniz. Kimse bana bunu anlatamaz. Üçüncü bir nokta, Hakimler ve Savcılar Kurulu'nun toplantıları gizlidir. Şimdi siz savcısınız, yargıçsınız, hakkınızda bir soruşturma yapıldı. Size bir yaptırım uygulandığını düşünün. Buna itiraz edersiniz. Bir itiraz yolu var. Daha büyük bir kurulda görüşülecektir konu. İtirazınız kabul edildiği takdirde tabii mutlu olursunuz. Kabul edilmediği takdirde sorarsınız. Neden kabul edilmedi? Size bir yanıt gelir. Dosyadaki bilgilere ve belgelere göre. Bu hiç değişmez bu. İtirazınız reddedilmiştir. Şimdi ne yapacaksınız? Size düşen şudur. Kara kara düşünürsünüz. Nasıl bir belge var bu dosyada? Nasıl bir bilgi var? Ay bilemezsiniz. Biraz önce sayın meslektaşım saydamlıktan, şeffaflıktan söz etti. Gün ışığında demokrasiyi gerçekleştirmenin yolu buradan geçer. Saydam devletten. Bunun örneği var mı? Var. İtalya'da herhangi bir yargıç ya da savcı kendisi hakkında kuruldaki görüşmeyi kenarda oturur ve izler. Çünkü o görüşme kamuya açıktır. Şimdi bakın burada ciddiyet var. Ne yapıyorsunuz? Gerekçeleri dinleyebiliyorsunuz. Elbette söz hakkınız yok. Kenarda dinleyeceksiniz. Ama herkes böyle bir toplantıda ciddi olmak zorundadır. Ne olduğunu da öğrenirsiniz. Şimdi yargının hükümete karşı bağımsız olmadığını ben burada tekrar vurgulamak gereğini duyuyorum. Artık yargı çökmüştür. Zaten Türkiye Büyük Millet Meclisi'nin Sayın Başkanı da bunu söyledi. Türk Anayasası'nın dedi 138. maddesi, yargı bağımsızlığı ile ilgili madde, ölmüştür dedi. Ölüyü diriltemezsiniz. Yeni bir düzen getireceksiniz. Yargının üçüncü bağımsızlığı, yargıçların birbirlerine karşı bağımsızlığıdır. Bu bağımsızlık da yine yüksek yargı organlarında var. Karşı oyunuzu yazarsınız, imzanızı atarsınız. Diyeceksiniz ki diğerlerinde yok mu? Evet, onlar da karşı oy yazabilir. Ama eskiden bir sistem vardı. O sistemde Yargıtay ve Danıştay üyeleri, başkanları ilk mahkemelerin vermiş oldukları kararlara göre değerlendirme yapar. Yargıçlara ve savcılara not verirdi. O not 2011'de kaldırıldı. Ben yıllardır bunun kaldırılmasını söylüyordum. Çünkü yargıçlar birbirlerine karşı bağımsızdırlar diye. O güzel bir adım atıldı. O doğrudur. Ve yine bütün yasalarda görüşmeler, yani yapıldıktan sonra bir oylama yapılır. Bu oylama daima en kıdemsiz üyeden başlar. Niçin? Bu da yargı bağımsızlığının bir boyutudur. Kıdemli üyelerin etkisinde kalmasın diye. Kıdemsiz olanlar. Dördüncü bir nokta, sokağa karşı yargı bağımsızdır. Sokağa karşı yargı bağımsızlığı her gün bu ülkede çiğnenmektedir. Basında, görsel basında, yazılı basında her gün yargıçların yerini geçerek hüküm kuran insanları görürsünüz. Her boyutta. Yazarı, çizeri, konuşanı. Herkes onların yerine geçip karar verir. Şimdi bunu gerçekleştirmek için Türk Ceza Yasası'nın 288. maddesini getirdiler. Bir yaptırım. Bu Fransız Ceza Yasası'nın 435-16. maddesinden, 434'tü galiba neyse, maddesinden alınmıştır. Doğru bir düzenlemedir. Ama bu düzenleme, bu maddenin hayata geçirildiğini bugüne kadar ben hiç duymadım. Yani sokağa karşı yargı bağımsızlığı tam anlamıyla Türkiye'de uygulamada işlememektedir. 5. boyutu yargı bağımsızlığı. Yargıcın yargılama yaparken kendi ideolojilerine, dünya görüşlerine ve bu arada inançlarına karşı bağımsızlığıdır. Onları ne yapacaktır? Salonun dışında tutacaktır. Bu da tabii yargı bağımsızlığının en etik boyutudur. Bunun ne dereceye kadar gerçekleştiğini ben sizlere söyleyecek durumda değilim. Onu bilemem. Kısaca önemli olan şu, anayasanın 138. maddesindeki o görkemli düzenlemeyi uygulamaya yansıtma hünerini henüz gösterebilmiş değiliz. Türkiye'nin en önemli sorunlarından biri budur. Burada bir örnek de ceza yasasında bulunan izin sistemiyle ilgili bir örnek vermek isterim. Şimdi ceza yasasında bazı 3 maddede izin sistemi vardır. Bu 4483 sayılı kamu görevlilerinin yargılanması ile ilgili yasadaki izinle ilgisi yoktur. Parantez arasında söyleyeyim, 4483 sayılı yasa gibi bir yasa şu anda hiçbir Avrupa devletinde yoktur, Asya devletinde yoktur, Latin Amerika Kara Avrupa'sından esinlenen Latin Amerika devletinde yoktur, Afrika devletinde de yoktur. Togo müstesna. Bizde var o. Biz onun ne yapıyoruz? O izin sistemini de gittikçe genişletiyoruz. Yok öyle bir şey. 19. yüzyılda vardı. 1870'te Fransa bunu kaldırdı. Orada da vardı. 1861'de Bolivya kaldırdı. 1831'de Belçika kaldırdı ve anayasayla bunu güvence altına aldı. Dedi ki bu konuda yasa çıkaramazsın. Biz ne yapıyoruz? O yasanın uygulama alanını genişletiyoruz. İşte MİT yasası vesaire vesaire. Bakın biz nereye gidiyoruz? Dünya nereye gidiyor? Parantez içinde buna da dokunayım. Öbür izin sistemine gelince o da şu. Şimdi bazen düşünceyi ilgilendiren suçlar vardır. Bu suçlardan Cumhuriyet Savcısı olaya el koyar, yasa kendisini bağladığı için dava açmayı düşünür. O suçlarda Cumhuriyet Savcısı dava dosyasını bir siyasetçinin önüne götürür. Bu her sistemde vardır, birkaç madde halinde. Amaç şudur, Cumhuriyet Savcısı siyasi bir değerlendirme yapamadığı için bir siyasetçinin önüne gider. Bu genellikle devlet başkanıdır. Devlet başkanı bakar, der ki bu davanın açılması ülkenin aleyhinedir. İzin vermiyorum. Ama bunu gerekçe de göstermez. Çünkü gerekçe gösterirse tartışma olur. İzin verildi, verilmedi, bitti. Çünkü siyasi değerlendirmeyi o yapabilir. Cumhuriyet Savcısı yapamaz. Biraz önce belirttiğim hani inançlara karşı, görüşlere karşı bakın bağımsızlık burada da ortaya çıkıyor. Cumhuriyet Savcısı bir yargı adamıdır. Bunu yapamaz. Bunu yapamaz. Ve buna benzer davalarda bizde Adalet Bakanları önceden görüşlerini söylemişlerdir. Kamuoyuna duyum. Hele bir tanesi bir dava açılacaktı, izin istediler. Ünlü bir isimdi. Dediler ki ne düşünüyorsunuz? Adalet Bakanı kasıla dedi ki ben devletime sövdürmem. Bitti. Yani izini vereceğim diyor. Ve öyle bir laf ediyor ki şimdi yargıcın önünde, yargıç olduğunuzu düşünün. Önünüze gelecek, beraat ettirseniz devletinize sövdürmüş olacaksınız. Değil mi? Mahkum etseniz Adalet Bakanı sevinecek. Siyasetin etkisi altında kaldığınız izlenimi doğacak. Şimdi bakın, kurumları iyi anlamazsanız böyle potlağı kırarsınız. Hepinize teşekkür ederim.
Professor, thank you very much indeed, and thank you for concluding this particular part of the session. Do we have time for question and answer, or are we eating into the coffee break? I have some questions here which have already been submitted by members of the audience, and what I thought I would do is invite the members of the panel here to whom these are addressed very economically to deal with them, because time is marching on. And I was going to start by asking Professor Selçuk this question, which has been put to him by a member of the audience here. The questioner says, we observe that certain circles, such as some of the media, try to make the courts disreputable, bring them into disrepute when they are not happy with their decisions. And in some circumstances, court decisions are not even executed or implemented. There we are. In some circumstances, court decisions are not even executed. What is your assessment of this in relation to the good conduct of the law in this country?
Bunun cevabı son derece basit. Hayır. Hukukun uygulanmadığını çarpıcı bir örneğini kendiniz vermiş oldunuz. Mahkeme kararı hoşunuza gitmediği zaman bağırmaya başlıyorsunuz. Zaten yargıçların önüne gelen her davada her iki tarafı birden yargıç memnun edemez. Hangi taraf davayı yitirmişse mutlaka size karşı bir şeyler söyleyecektir. Hatta bazı suçlamalarda da bulunabilir. Yani yargı yaşamında hep bunları biz yaşadık. Onun için bu yeni bir soru değil, bizim eski huyumuzun dışa yansımasından ibarettir. Teşekkür ederim.
Thank you very much indeed. The next question is addressed to Helena Lisuchova. And the questioner says, we observe that as GRECO, looking at the GRECO website, you are counting corruption as one of the top threats to the rule of law. Why is that? Can you explain why? And what does corruption mean within the confines of your remit?
Thank you. Well, we've heard today in the morning already quite a lot on the threat to trust in legality in legal process. That is what is also covered by GRECO and what is considered as a process which undermines the trust. Corruption is understood also as a process that undermines the trust of public into proceedings, both in administrative proceedings or judicial proceedings, or private relations in private business. If you are accepting bribe, you are getting an advantage that you are not entitled to. The equality of parties, the equality of people, of parties is disrupted. The public then loses trust in the processes, in the guarantees that the state should give them for their rights. As to the corruption, what is corruption? We don't work with a definition of corruption. As you said earlier, there is no single orthodox definition of rule of law, and there is neither one for corruption. So as I said, corruption is any advantage that you are not entitled to and you get in the process of your work. It doesn't have to be only monetary, pecuniary benefit. It can be a service, vacation, invitation to dinner, to a weekend somewhere. But it can also be, as we were discussing in December at a conference in Prague, it can even be the providing sexual services. I should go back to the policies of the Council of Europe. The Secretary General Jagland announced last year that the committees of Council of Europe should all ensure that the gender equality mainstreaming is present in all the policies and activities of the Council of Europe. We in GRECO introduced this aspect, the corruption and gender, to our plenary, and during the year 2013 we came up with some outcomes of the discussions. We had a conference, and there, as one of the studies that was presented, namely on higher education and corruption in higher education in Ukraine, there it came up that even sexual services might be considered as a bribe. So that's why I mentioned that as well. Thank you.
The next question is directed to Attorney General Sorrell. Do you think it is right that governments should be able to influence the naming of particular prosecutors or the placing of particular prosecutors or removing particular prosecutors or judges who are concerned with particular criminal trials and investigations? Or is that something that you would find rather strange?
No, I think that's inappropriate unless the appointment of a special investigator or a special prosecutor is a response to legitimate questions that have been raised about either the competence of the investigators or the independence and integrity of the prosecutors. But if there's attempts to influence which are designed more to restrict determination of truth, getting to the actual facts, then I think that's outright inappropriate, no matter whether it's a high executive branch official, a member of the judiciary, or legislative branch that's seeking to limit or to prejudice an investigation.
Thank you. And the last question is addressed to me and is in two parts. Does bribery under English law, is it restricted only to public servants or officials? The answer to that question is no. It applies to anyone who commits the crime described in the Act. It doesn't matter whether you're a public official or a private citizen. If you've done something which constitutes bribery or corruption, well, then you're going to get prosecuted. And the second part of the question was, is it permissible? This is a question which rather answers itself. Is it permissible for governments to initiate criminal or other investigations into private citizens or corporations for reasons other than strictly criminal law reasons? Well, again, the answer to that is no. Governments should not direct the use of the criminal justice system for its own private or political ends. The criminal justice system is there to be administered by independent prosecutors and judges, and it would be an abuse of the rule of law were it to be otherwise. That, I think, is enough from us. Thank you, my fellow panelists, for your contributions, and thank you for listening to us. Thank you for listening to us so patiently, and I'm sorry that my failure to abide by the rule of law has meant that you have had your coffee breaks slightly curtailed, or at least postponed.